Hello and welcome to today's episode of Immigration and Jobs Talk Show. I'm your host Sam and I'm back again with a very exciting episode that is lined up for you today. So before diving into the topic, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So use of information is at your own risk. All right, so folks, once again, welcome back to Immigration and Jobs Talk Show. I'm Sam, your host. And today we have got again a very timely and crucial topic. That is the new H-1B rule. What employers and workers need to know and why it's a game changer. Well, it's actually a game changer because the new H-1B rule has modernized the visa process. But how, what are the key changes, then how does it impact both workers and employers and what you need to do to stay ahead? To answer all these questions in detail, we have a very special guest with us who has joined us for the fourth time. That is attorney Poonam Gupta. And she has over 25 years of experience in immigration law, plus a solid background in intellectual property and litigation. So, welcome, Poonam. It's always a pleasure and lovely having you with us on our immigration show. And it feels so great to have a show with you and so much to learn from you as well. So, thank you so much for joining us.
My pleasure, Sam. It's great to be back, and I'm excited to bring the key topics and key learnings from this new H-1B rule that's finally come to fruition. It was first proposed in October of 2023, and it has now just been released and will become effective January of 2025. So, super excited to delve in, and I
Yeah.
hope people have lots of questions. If not, I have lots of things to share because a lot is there to pack and unpack.
Absolutely, that is, and but before diving into our today's topic, Poonam, I would like to know it's just 5 days to go Christmas. So, how is your Christmas preparation going on? Are you excited?
I am super excited because I'm going to take some time off and unwind and relax with family and friends. And so, super excited about that. And I hope everyone else does the same.
Absolutely. I think all our viewers are also very much excited because it's Christmas time, right? It's super exciting time, and holiday days also are just coming after a few days. So,
Sure.
yeah, I think with that, also, folks out there, let me tell you that we are also live on YouTube, LinkedIn, Facebook, and on X as well. So, watch this session and put all your questions, your queries, whatsoever you would like to know from Attorney Poonam Gupta, and we would be more than happy to have them. All right, so let's begin with this very first question of mine. That is, Poonam, what is, or can you please explain the main changes that has been introduced by the new H-1B final rule?
Sure. So there are lots of changes in this new rule.
Mhm.
As I mentioned previously, the first iteration of this rule was proposed back in October of 2023. Partial implementation of the rule happened last December, and those rules went into effect in January of 2024. The remaining portion from that 2023 rulemaking proposed rule has now been issued this week, and this will go in effect on January 17th, 2025, just days before the new president takes office. What is the purpose of this rule? The purpose of this rule is to codify USCIS practices and introduce some new provisions. So, some
Mhm.
of the new provisions that were introduced include an expanded and more robust definition of specialty occupation, which is the hallmark of H-1B. And to qualify for H-1B, the second is the elimination of the itinerary requirement, which is if someone is placed at any at a location, then previously employers were required to identify when they will be working and where, for how
Mhm.
long, and so on, and that requirement has now been removed. And the most exciting, one of the most exciting pieces of the rule is the expansion of the definition of not for profit and what it means to be uh, cap exempt and how to secure cap exempt H-1B. The expanded definition makes it a lot easier for organizations to qualify as cap exempt and thus hire more workers. And it actually requires people to not directly work at those organizations, but even if they're working uh, with that organization and working towards that essential function of that organization, they could still qualify for this cap exemption. The next exciting part that's been introduced in this, which was much awaited by entrepreneurs across US, very for a long time, is the option for startup owners to sponsor themselves for H-1B as long as they have an entity, a company set up. And even if they own the majority stake and they have the majority ownership, they're still able to sponsor themselves. In addition, there is the codification for that there has to be a bona fide job offer, um, amended petitions, that when an amended petition is required, deference policy was codified, as well as the evidence of maintenance of status that is required for each petition for change or extension of status. The one key piece that has been in USCIS practice, but has now been codified, is USCIS has expanded its authority to conduct site visits to ensure compliance with H-1B requirements, including for third party placements, and non cooperation with the site visits could result in a denial or revocation of the H-1B. So, in short, I know it's a lot that I packed in, but in short, that is what is a quick summary of what's happened in this new H-1B rule.
All right, all right. Thank you so much, Poonam, for letting us know about what are the main changes that has been introduced by the new H-1B final rule. Also, Poonam, do you think that the new H-1B rule is going to benefit workers and employers? And if yes, then how?
So there is definitely benefit that will come through for everyone. The biggest benefit will be the clarity that comes through. There is clarity on what is specialty occupation, what is required, the government clarifies in their proposed rule in their rulemaking document, the notice in the Federal Register, and address the various scenarios, and they go in great depth on what is it that is required for each. When is it considered specialty occupation? When is it not? When is a general degree okay? When is it require a specialized degree? In most instances, a general degree may not work and may not qualify someone for an H-1B because it will not be considered specialty occupation and so on. So there's definitely clarity around that, and removal of the itinerary requirement is a huge benefit, especially for IT staffing companies. That really helps. That should help. What may not be as beneficial may be the increased site visits, the increased access, or sorry, the streamline. I mean, there is streamlined processes, but there's also additional requirements on what is an employer required to present when it comes to qualifying for an H-1B. The government has the authority to request contracts, whether it is with end clients or third party clients, or there may be intervening agencies before the H-1B employees placed at an end party client, and the government has expanded its authority to request any contracts or master services agreements or the like. So that may add more burden on the employers, but by and large, I think all in all, this rule is a positive. is a good thing. There are a lot of good things about this.
All right, that's great. Also, Poonam, there's some mentioning about a specialty occupation. So I would like to know that how does the new rule change the definition of a specialty occupation for H-1B visa, and what does directly related mean for the required degree too?
So USCIS has gone and spent considerable time in explaining that they are not actually changing the definition drastically. All they are doing is codifying what USCIS practice currently is with regards to specialty occupation. So the current practice is that the government requires a nexus between the degree that the individual, the beneficiary, or the employee has and the position. So there has to be a direct connection, a direct nexus between the two. If a company cannot show that there is a connection between what the degree required for the position is and what the person has, then there may be problems. But to the extent that a company can show that there is a nexus and there is a connection, then then there should not be any problem. It's more clear compared to before, if that makes sense. I can give an example. So one of the examples that the government lists in the rulemaking is an engineering degree for a software developer role, and they say not any engineering degree can surely qualify unless the government shows that there are specific courses within any engineering degree that would help in that software developer role. So, for instance, a chemical engineer or a mechanical engineer, by definition, at least on the title, and the government has spent considerable time explaining that just the title of the degree is not material. It is what the substance and what courses are taught in that degree. And because titles vary from university to university, program to program, the titles are not dispositive. It is what is the actual coursework and how that relates to the role that matters. So that is what directly related means, that there has to be a direct nexus, direct connection between the coursework and the position.
All right. But also, Poonam, I have this question in my mind that now we can see another way of specialty occupation definition. So now it shouldn't be much specific about the work that the workers are going to opt for. So do you think it's going to be beneficial for the company because if specifically not that employer is looking for that specific degree, that overall degree can be applicable. So do you think it's going to benefit, or that employer or that worker needs to be highly qualified in that specific work, then only it's going to beneficial for the company?
So there are several pieces to this, Sam, right? One piece is when the person has, so the position can require one degree or it can require multiple degrees, right? And the government has always held this position. And what they've done with this new rule is codified that position, is that if an employer requires multiple degrees, it has to show how each degree is relevant to the role. So,
Yeah.
for instance, if a position requires finance, economics, statistics, all related, then it has to show what part of the finance degree is directly related to the role, what part of the economics degree is directly related to the role, what part of the statistics degree is directly related to the role, and so on. So that is the directly related part. In terms of, does it exclude individuals that have experience? No. The government is still going to look at, as it currently does. It's not a change, nothing's changed in that perspective. It's only clarified and codified what USCIS currently does. That if someone has an Indian degree, an Indian bachelor's degree, which is a 3-year degree, and a few years' experience, then there is a possibility that the combining the degree and the experience, the person could qualify for a US H1, an H1B role based on a degree equivalency, which is based on just the the 3-year degree plus a few years experience, which would equate to a US bachelor's degree, which, as you may know, is required for an H-1B. So the government looks at the totality of what the situation is, and not just the title of the degree, not just
Right.
the experience or whatever. So it's everything combined together.
Absolutely. And also, Poonam, we have one of our viewer here, and here's Chetali here, and she's watching us from LinkedIn. So, Chetali has another question that does codifying help H-1B holders? Will it protect them from the next administration from, I think,
Making any drastic changes to the H-1B. So,
yeah,
yes, thanks, Chaitali, for joining us. The question is a good question. Codifying helps both the employers and the employees because it provides clarity to the to everyone. What is the standard? What is required in terms of, will it protect someone from drastic change? There is codification of the deference, as in the deference policy, which means that if an employee is continues to work for the same employer and applies for an extension of the H-1B status, then unless there is a drastic deviation from the previous application, the government will give deference to that same application, that extension application. So, to that extent, there is a limited protection under the previous Trump administration. We saw individuals who had held H-1B status for an extended period, in 10, 12, 14 years. Their H's were denied on extensions because the Trump administration revoked the deference policy, as in every case would be reviewed afresh as if it was a brand new filing. By codifying the deference within this new rule, the government is providing a limited amount of protection, not a blanket protection. They've refrained from expanding the deference, but there is some limited deference.
all right. And thank you so much, Shadali, for your question. As this was my about to question because I was about to ask this question only. But that's okay. I think, Poonam, you have explained it. And Chitali, if you still have any follow up question or would like to know any other topic or any other question that you have in your mind, then please feel free to post them in the comment section. And for an hour, we are here. So please go ahead and utilize this opportunity. We will definitely take your question up. And here's another question from Anisha. And Anisha is asking that does the rule address dependent visa like H4 or their work authorization?
No, Anisha, thank you again for joining us. Unfortunately or fortunately, we don't know, we'll see. But the rule is focused purely on H-1B and does not address any dependents or the H-4 work authorization. There were some comments in the rulemaking about immigrant visas, and the government said that is the outside the scope of this rulemaking. But there were no comments about, or at least I didn't see any comments about dependents. But there are definitely no rules or no impact or changes to the dependents or their work authorization in this new rule.
All right. So thank you so much, Poonam, and thank you so much, Anisha, also for your question. And Chitali is saying thank you. This was really helpful. Thank you so much, Chitali, also. And let's move ahead with another question, Poonam, that I have for you. That is, how does this rule impact the eligibility of workers with degrees in business administration or other fields that were previously considered general?
Right. So this is where this may be slightly problematic, right? Individuals that had a general business degree, and the government clarifies that it is only the bachelors of business administration that may be problematic without a specific major or a minor. When there is a major in that, even in that business administration degree, it is considered specialized. It is when there is no major that that is a problematic issue. If there is a major, no issue. If it is a master's in business administration, again, no issue. They are considered specialized by virtue of being master's degree. But it's only the bachelor's in business administration, which did not have a specialization, that may run into trouble under this new codification. Everyone else should be okay.
All right. Okay. So here we have also Anisha, and who says, "Okay, thank you so much, Anisha." And to you also, if you have any question or follow up, then please go ahead and post them on the comment section. We will take them up. And thank you so much, Poonam, for detailing that up and answering all the questions very patiently. Here's another question that I would like to know from you about the site visits. So, what role do site visits play in the new rule, and what should employers be prepared for?
So previously, site visits were always part of USCIS arsenal. The FENS arm of USCIS, which is the fraud detection unit, always was involved in investigating any situations where they thought there was fraud in the USCIS, in the H-1B applications. But with this new rule, they've codified the authority and said we can conduct site visits to see what is happening and to request information from the employer as well as the employee. And these site visits are unannounced, but if there are attorneys that are representing those employers, they can ask the site visit to be rescheduled so that the attorney can be present. The attorney can join by phone as well, but it is possible that they can reschedule it uh, to allow the attorney to be present. But they are very, very clear that if the employer or the employee do not cooperate or provide the requested information, it can result in the denial or revocation of the H-1B. So it is absolutely critical that employers are prepared for any site visits. They are prepared with having all their documentation absolutely in order so that they are well ahead of the curve. In addition to the site visits, I anticipate that under the Trump administration, the site visits will definitely increase given the focus on enforcement. In addition, I imagine the I-9 audits will increase under the Trump administration as well. So those two, while separate, are all part of the immigration compliance, which every employer, if they are not thinking about, should think very, very seriously about. These are not things to take lightly. There are severe consequences of not being prepared, including revocation of petitions, including fines and criminal penalties in some situations in an I-9 situation. So there's a lot to be prepared, and I urge all employers to talk to their immigration counsel, talk to their attorneys, and get ahead and be prepared for what's coming very soon.
Absolutely. I think everyone should be very much aware about this, and they shouldn't be taking this thing lightly because some or the other it's going to harm them. But also, Poonam, as you said, that we can see in Trump's administration the site visits going to be more stricter. But
Correct.
till now, we have heard this from most of the people that most of the people are against site visit. They don't like this concept, and Trump is completely in favor of this. So, what's your take on this? Do you think that site visits can be beneficiary, or is it going to some on the other? There are some other challenges that people they might not know about it.
So, site visits are a double-edged sword, right?
Mm-hmm.
Um, For employers that are fully compliant,
Mm-hmm.
site visits help establish their credibility with the government. They help cement um, the perception that the government may have
Mm-hmm.
for how a company and the amount of scrutiny that the company may receive from the government going forward after a site visit. But for employers that are playing fast and loose with the rules, or you know on the edge of compliance and not really focused on compliance,
Mm-hmm.
this may be problematic. So it is important to focus on the compliance piece more than ever under the upcoming administration.
Right. I think very well explained. And meanwhile, we also have another viewer, Zishan. So, Zishan is here with another question that can you please talk about opening up the company or startup?
Sure. So, Zishan, welcome, and great question. A lot of students, a lot of individuals want to start their own companies as a student on OPT or so on. And up until now, being you could start a business on OPT, but when it came to STEM OPT, you couldn't, or you could, but they could. I mean, there were ways around it, and there still are ways around opening your own and working on your startup while you're on OPT or STEM OPT. But then what about after you're done with OPT and STEM OPT? What was the path forward? Up until these regulations, there was no path forward. Now there is a path forward. Individuals who have a majority ownership in their companies, not them individually. So the government has made this distinction. It is not individuals, not entrepreneurs who are looking to sponsor themselves that will be able to benefit from this rule. It will be individuals who set up a formal entity, a company, of which they may own the majority share, majority ownership, but that company is able to sponsor the owner for H-1B as long as the individual is working in a role or performing duties that are majority specialized in nature, that are aligned with their degrees, that have a direct connection to their degrees, and for the majority of the time, they're performing that role. The government does not expect 100% of the time to be on those specialized duties, but only a majority. They've given and acknowledged that a company owner needs to do other things, whether it's making copies or making calls or seeking investors or pitching to business or pitching for funding or anything else, as long as that running of the business does not overtake the individual's role, they can qualify for H-1B. One of the guardrails that they have put in place to prevent fraud and abuse of the system is that the petition will be only valid, that H-1B initial petition by an entrepreneur for their sponsored by their own company for themselves will only be valid for 18 months, and then it can be extended for another 18 months, during which time they will have to show the government what percentage of time they've been spending on what duty. And once, if the government is satisfied, they will extend that initial H-1B for an entrepreneur by another 18 months. And then after that, they can get a full 3 years. So they will be able to get a full 6 years with their own company without relying on any other employer, which is groundbreaking by any stretch, which is monumental and a welcome relief for entrepreneurs.
Wow, that's so good. Okay, so Zishan, I hope you got your answer. And still, if you have any follow up question, then please go ahead and post them on the comment section. And we have another question from Chetali as well. But here's a request, Chetali, please wait for some time. We have another questions also. So let me take from YouTube user also. That's Kunal. So, I own a small tech consulting firm and rely on H-1B workers for critical projects. With this new rule prioritizing higher wages, does it mean I'll be forced to pay top tier salaries just to stay competitive? What options do small businesses like mine have?
Kunal, welcome and thank you for that question. I want to clarify one thing. There is no requirement under this new rule that forces employers to pay higher salaries. The employers are required to comply with the LCA requirements. An LCA is a labor condition application, which is a prerequisite for an H-1B. An LCA mandates that an employer pay an H-1B employee a prevailing wage. That is mandatory. That does not change. And nothing about that LCA or the prevailing wage is changing under this new rule. So if you were competitive under the previous version of the H-1B rule, you will remain competitive under this new rule as well. Nothing's changing from that perspective. The only thing I would urge you to do is to make sure that you're following, um, taking steps to ensure all your immigration compliance pieces are aligned. Your For LCAs, your public access files are available because there will be more and more Department of Labor audits that I anticipate under the new administration. There could be site visits for smaller employers. If you're placing employees at third-party sites, then what is the difference between whether those employees being placed are the employees being placed on a small project, which is a discrete short-term project, or is it a long-term assignment where that employee becomes a part of that company's hierarchy and organizational structure, and you are providing additional talent to that company. So the requirements have changed in those two scenarios, but by and large, from a wage perspective, nothing has changed. So I don't think you have anything to worry from a wage perspective, but there are other things that you need to be mindful of.
Absolutely. Thank you so much, Poonam, for your answer. And Kunal, also, I hope you got your answer. But still, if you have any other question or still you're navigating any tricky legal issue or want to have guidance, then you can also contact attorney Poonam Gupta. And you can email her on info@summit-legal.com. And you can also visit her website, that is www.summit-legal.com. So this is for all our lovely viewers who all are watching us right now. You can also contact attorney Poonam Gupta, and I'm sure she is going to give you a brilliant advice and definitely going to navigate all your legal issues smoothly. All right, so let's move ahead with Chetali's comment. That is, what about employees working remote? Is there a requirement for the employer and employee to be present at the company site?
Great question, Chetali. The government has refrained from imposing limitations on remote or in person or any of that. All they've said in this new rule about this requirement is whatever the employer's preference is, the only thing they need to be mindful of is that they're complying with the LCA requirements. If an employee is going to work 100% remote, and there are plenty of companies that are fully remote that don't have any employees on site, then as long as they are mindful of where their employees are and that the employees are only working from the location for which they have an approved LCA, they should be fine. If the employees move to a different location, please note it is now codified. It was always, has been required for a few years since the decision in matter of Simeo, but now it's codified under these new regulations as well in this new H-1B rule, is that anytime a new LCA is required, an amended petition needs to be filed. The employee can start working as soon as the petition is filed, but there is no grace period for that amended petition to be filed. If there is a change, the petition must be filed before the change takes effect. It is absolutely critical to note that there is no grace period from any changes, material changes to the H-1B. And that includes change in location outside of the certified LCA. If person moves to a new area, then a new LCA is required and a new H-1B petition, an amended petition is required. And for that, as long as the employers are complying with that and mindful that the employees are following those rules and staying put, then there should not be an issue. There's no requirement that USCIS is not managing, micromanaging where an employer and employee need to be. All they're saying is that employers should comply with the DOL and regulations pertaining to LCA.
All right. So, Poonam, we have another questions too from our Facebook people as well. But I would like to ask one more question from you: that how will the new rule is going to impact the companies that place H-1B workers at third-party client locations?
So third party, I believe I talked about this when in response to Kunal's question, but third party placement, the one benefit is that there is no requirement to include an itinerary with the petition. But what is required, and the government will inquire, is they can ask for contracts. They've codified that. They said we will ask for contracts, any relevant information that helps us understand what the relationship is. And then the nature of inquiry that they have is twofold. One, what is the nature of that placement? Is that placement a short-term discrete project placement? And the employee, the staffing company, for instance, is are they placing them for a project that is discrete and not adding to the headcount or supplementing the company's headcount? Or is it an additional talent that the staffing company or the company is providing to the end client such that that placement becomes part of that headcount or that organizational structure and a critical piece of that function within that company. In the latter situation, where the employee is placed as part of a bigger team within the end client, then the big change now is under these new rules is that the requirements, the education and degree requirements for the role that is being filled at the end client control. It is not the H-1B employers, the that requirements that control. It is the end client's requirements that control. So if the end client requires X number of years and degree in a specific area, then the employee has to be able to meet those requirements, and the government will ask for those specific requirements. So please be prepared to ask for those requirements from your end clients and be very clear that that is something that may be required. So that may be something you will employers will be asked to share their MSAs and contracts and statements of work and so on. But please be mindful that the government can also come back and ask for requirements, the degree and the position requirements for the position that's being filled at the end client.
Absolutely. They have to be very mindful with this. And thank you so much, Poonam, for taking these questions up and explaining all them in detail. And we also have a few questions that I would like to take. That is of Roshni's. Wait, this one. Yeah. So Roshni is saying that I work in a non-tech field, specifically healthcare. Seems like this rule is designed around tech jobs with high salaries. So do you think that workers in fields like mine will be at disadvantage under the new system?
Roshni, thank you for joining, and a great question. So, while there is a lot of discussion around IT companies and staffing agencies and so on, there's actually a huge advantage to companies, potentially in the healthcare industry, if they are affiliated with a hospital or a university that is a nonprofit. There is, as I mentioned very briefly in the beginning, there is an expansion of the definition of cap exempt. Currently, hospitals and universities are allowed and do benefit from not being subject to the H-1B cap. And with the expansion of this cap exemption, um, my sense is that the healthcare field will benefit even more and not less. So there is actually a bigger advantage to the healthcare industry, in my view.
All right. So, thank you so much, Roshni, for your answer, and sorry, for your comment. And let's take one more that is of LinkedIn user that we got right now. And it's saying that does the end client, in case of third party, need to provide a job description?
Correct. And thank you for joining. Yes, the end client, again, USCIS could ask not only for a job description, but also for the position requirements in terms of education and experience that is required for that role to determine whether or not whether that individual who's being filled in that role qualifies for that role. So yes, job description can definitely be required in addition to the requirements.
Okay. So I think from control we got to know the user is Jigarji. So welcome Jigarji, and thank you so much for your question. And it would be lovely if you could also ask another question that you would like to know, and we will definitely take them up. Meanwhile, I would also like to take Ashwarya's question. And she's saying that if my employer decides to sponsor me for an H-1B but can't afford to pay the top wage levels, will I still have a fair chance in the lottery, or is it now all about money?
Ishwarya, thank you for joining, and that's a great question. So the one thing is very clear and has always been clear that the H-1B program protects is designed to protect not only US workers but also foreign workers. Every employer is required to pay a prevailing wage as they attest to on the labor condition application included with the H-1B. An employer cannot bench an H-1B employee without paying them. There is no benching time that's permitted under H-1B. So if an employer cannot pay the prevailing wage, then there is a problem. But it doesn't have to be top wage levels. The wage level is determined by the job description and the requirements for the role, and as well as the location for the role. So if your role, like some of the situations, and a legal way to get around the wage level issue in some situations is to move away from areas where the wage levels may be higher and move to locations where the same role can be performed for a lower wage. So if the role, for instance, is a remote role, then it is perfectly legal for the company to mandate that the employee work out of a certain area that is not as high in their salary. And if the employees do not conform to being restricted in that area, then the employees are exposing the employers to compliance issues and violation of H-1B. So it's in both the employer and employee's interest to manage and make sure that they comply with the LCA requirements. And as I said, it is not about paying the top wage levels, it is about whether or not it complies with the law. And in terms of fair chance in the lottery, The lottery is not determined by what wage level you're at, where you're located. It is simply now, since 2024, the H-1B lottery is beneficiary centric, as in each individual gets a fair chance in the lottery, regardless of how many employers may sponsor them, or regardless of which country or which occupation or what level they're coming in at. H1B lottery is agnostic to all these factors. The only information the lottery requires is the individual's name, the individual's date of birth, and their passport information, purely for identification purposes and to prevent fraud. It has nothing to do with money, it has nothing to do with anything else. The lottery is completely separate. And then, if you're selected in the lottery, then the employer is required to comply with the H-1B requirements, including the LCA. I hope that helps you, and good luck.
Well, that wonderfully explained, Poonam. And this was also a very eye-catching comment that I also wanted to take that up. And I have some other questions from Facebook group as well, but we have lots of viewers that has been worried on today's topic. So I think firstly I'll take their questions. So let's take Aman's question. That is, hi, this is Aman. I heard that the new H-1B rules have eased restrictions, allowing entrepreneurs to establish their own companies. I'm wondering, can I continue working for my current employer while simultaneously filing for an H-1B through a company I create? Is that possible?
Welcome, Aman, and thank you for joining. And a great question. While I did address the piece about employer and entrepreneurs being able to sponsor themselves, this is a nuance. The question that you raised is a nuance that is also addressed in these new rules, and that is an individual, in addition to an individual setting up their own company and being sponsored by their own company, they're also able to file for a concurrent H-1B where they can work for multiple H-1B employers as long as they have a valid H-1B approved for each employer, whether it is one employer or multiple employers. And in the scenario that you list out, you could work for if I'm understanding you correctly, you're planning to work for two employers. One is your current employer, and the second would be your company where you are the owner and your company would be your employer. And yes, that is possible. Concurrent employment is possible. And one of the nuances that may benefit someone else, if not you, Aman, would be that the individual, if they are able to find or they're working at a cap exempt H-1B employment, they could work for their own company simultaneously without going through the lottery ever, as long as they continue to work for that cap exempt H-1B. I hope that helps, and good luck.
All right. So I think, Aman, you had a great question, and we would like you to ask more questions. It would be so great to answer your comments and your questions. And next, we also have another question from Jigger, I guess. And he's asking that my LCA is filed for another state at client side. Client has allowed me initial 2 months to work remote to prepare for relocation. Do I need to change anything in the petition?
So if your LCA is filed for a state another than where you are currently, the client does not have. I'm not sure I fully understand what you say. The client has allowed you 2 months to prepare for relocation. Does that mean that your LCA has your current location as well as the client site, or only the client site? If the LCA only has the client site, then you are not permitted to work from any location other than the client site. If the LCA lists your current location as well as the client site, then that flexibility makes sense where the client is saying you can work where you are for 2 months, and then once in 2 months, you need to relocate to where the client site is. So this is the only piece that I would request that you check. If it is both locations, then you're fine. Nothing needs to change. Yes, thank you for confirming that it has both, because that is critical. So if it has both, you're fine. The client has given you the flexibility and the comfort of taking 2 months to relocate, but you need to move to the client site within the 2 months as they have requested.
All right. So I think, Jigger, you got your answer. And still, if you have any questions, then please feel free to comment them. And right now, I think, Poonam, I would also like to take some of the questions, that we got from our last episode. So, Control, I would like to share the screen and also want to know, Poonam, that, from our last episode, we got some questions. So, I would like to take them up as well.
Sure.
So,
Um,
yeah.
and
Mhm.
also, I believe there is a question from Sudhir in the chat that we should address as well that we didn't get to. But happy to answer this J1 while we look up that Sudhir's question. Could you please put up the J1 question from
Okay,
last?
okay. Okay, Poonam, so let's take the Sudhir's question first.
Oh, sure.
I
Whatever.
think I think now we are getting confused, but that's okay. Let's take Sudhir's question first. So, yeah. So here's a question that Sudhir is asking, that I have heard there's more scrutiny on the employer-employee relationship under this rule. I frequently place H-1B workers at client sites. So what does this mean for my business, and how can I prove compliance to avoid trouble?
Great. Thanks, Sudhir, for joining, and thank you for that question. As I have been harping on incessantly on this topic today, immigration compliance is critical. You need to have documentation to prove the employer-employee relationship per se. All you need to do is to show that you control the employee's work and you are managing their work at the client site. In terms of how to avoid scrutiny, as long as you are compliant and have all the paperwork that shows the agreement that you have with the end client, what work the H-1B employee will do at the end client, what are the requirements for the end client, and the distinctions that I made between whether it is a discrete project for an end client versus whether it is a headcount increase for the end client. As long as you have clarity on that, if it is the latter, you should get the job description and the requirements for the role and ensure that the employees that you place at before you place the employees at their role, so that you can confirm that those employees will qualify for H-1B. Um, as long as you have all your documents, I don't anticipate that you need to do anything extra on top of it, but you do need to maintain your corporate documentation and your contracts fairly carefully and more diligently and much more organized, so that if you're ever questioned about it, you have them handy. And it may be worth discussing this change with your end clients to say, so that they are prepared for providing that information. There are plenty of clients that we've heard where the end clients are hesitant and reluctant and sometimes outright deny any requests for cooperation for H-1B for employees placed on their side, on client side. And it's worth proactively bringing this up with your end clients so that you can avoid any compliance issues or any scrutiny down the road. But if you are compliant and if your end clients are cooperative, then it should not be an issue whatsoever.
All right. So here we have another question from Amit too, and Amit is saying that I run a staffing agency and place H-1B workers at different client locations. So does this rule mean I'll have to provide more paperwork or evidence of work relationships? If so, then what kind of documents are we talking about?
Great. Thanks, Amit, for joining, and thank you for that question. You are correct. There is a possibility that you may need to provide more paperwork and more evidence of the relationships. Um, it's up to the government what information they want, but proactively, when you're filing these H-1Bs going forward, I would suggest, at least for the petitions that you file after January 17th, to include proof of any end party placement. If you are placing them at a third party, then proactively provide your contract with that third party, the statement of work, the scope of work, and again, if it is a discrete project, then you don't need to provide anything else. But if it is a headcount increase or where the employee will become part of the organizational structure of the end client, then you should proactively ask for the job description and the job requirements for that role and provide them with the H-1B filing to and prove that the employee has the necessary skills and the specialized knowledge to qualify for that H-1B. So yes, there are more documents, but they are common sense documents. But agreed, it is more burdensome. There is a higher burden in that sense on the employers, but the goal is to ultimately prevent fraud and abuse, which ultimately benefits everyone. So, in short term, yes, it is problematic and more burdensome, but long term, I think it only helps all of us if we proactively provide all the information upfront without the government asking for it.
Absolutely. Wonderfully explained, Poonam. And I think, our viewers are also loving your insightful conversation that you are sharing with us today. And also, we have RK. So let's take RK's comments as well. So RK is saying that why so must employers concern about site visits? With more site visits, it can help with the improving the views that there is a lot of fraud in the H-1B program.
Right. So, why should the employers be concerned about site visits? Up until now, the site visits it was optional to cooperate with the site visit, if you will, but now it's mandatory. Under this new rule, employers and employees are mandated and required to cooperate with the government. If they do not, then the H-1B petition could be revoked or denied, depending on where they are in that state. If the H-1B petition is pending and then the site visit happens, then if the employer does not allow the FDNS officer, access to the site to whatever documents they want and confirm whatever information they want, then there is the potential for denial of that H-1B. If the site visit is after the H-1B is approved, then, and if the company does not cooperate or does not provide all the documents, then there is the potential for revocation and more site visits. So it is in the best interest of the employers to comply with the site visit requests and help um, address any concerns for abuse. And I have to tell you, these site visits are random and common. We've had situations where employers, like the same employer, had three, four site visits in a span of 1 month. And it all worked out. The questions were not crazy, intrusive, or in any way something that were not anticipated. And there were no questions that we did not have easy access to. I would also highly recommend, whenever you get notified of a site visit, or if an officer just shows up at the door, which most of the time they will, then you should call up your attorney. And if the attorney cannot join by phone, or if the attorney wants to join in person at the time of the site visit, to request the officer to reschedule the site visit at a time when your attorney can be present. You, I would not recommend any employer to go through the site visit without their attorney, just because it gives the attorneys able to address those questions and address anything that the officer may be asking that they should not be asking right at that point, and push back if needed. But most of the time, in my experience, it's a fairly straightforward request, and just providing that information helps not only that employer but everyone else.
Absolutely. And I think, Poonam, site visit are being a very hot topic nowadays. People are very much concerned about it. And I think we have another follow up question or follow up comment from RK, that is, with more sites, this will allow the government to publish data to show X amount of companies and compliant. This concern about this provision may wrongfully imply that there is a lot of fraud. What do you say?
Thanks, RK, for that. I'm not sure exactly what you're trying to say, but what I can discern is that the government occasionally does publish the site visit data, or other data, not necessarily how many site visits they've conducted, but they do provide some data about the workings of the FDNS. And there is a there is some fraud in the H-1B program. There are some unscrupulous employers that want to take advantage of the H-1B program,
Yeah.
that exploit workers and do not pay them as they should, or do not comply with the LCA requirements. And that is the goal of the site visit, to identify such unscrupulous players, such unscrupulous employers, and take them out and shut down their programs so that it doesn't impact the integrity of the broader H-1B program and everyone can stay compliant.
Absolutely, and I think that's how, anyone. I mean, I don't think that there should be anything that people should be scared of site visit, because if you have proper documents and if you are fully aware with all the updates, then I think it will be safe and there's nothing to be worried about. And sooner or later, it's very important, friends, to stay updated. So yeah, that's what I would like to share. And here's another question, that is, does the new rules regarding end client documents also apply for assignments started and petition approved before 17 January as well, or only for new petitions?
Thank you for asking that question. It's a great question. And yes, these new rules go into effect on January 17th and will only apply to any petitions that are filed on or after this date. So if anything is initiated or approved before this date, these new rules will not apply. But to be very clear, these are just codifications, and some of this USCIS is already doing and already requesting proactively. And all the new rules do is codify and request that an employer is mandated to provide these. Up until now, the government would issue a request for evidence asking for this information if they felt that the employer did not provide sufficient information.
All right. Also, Poonam, as we have crossed 1 hour, so I would just like to know it from you. Is it okay if we could extend for 5 more minutes our session?
Sure,
Oh,
we can.
that's
I know there's a lot of questions, and there will be a lot of questions if people become aware of this. And
absolutely.
happy to answer as many questions. So please keep those questions coming. We have posts on LinkedIn and all the other platforms. Please continue commenting. We will continue to address those questions even after this event is over, and if needed, maybe come back another time. But for now, please continue to comment and post your questions.
Absolutely. That's so sweet of you, Poonam. And also to our viewers, as Poonam said, that please go on commenting and posting your questions. And even after the show, even after the event ends, we will definitely take them up in our upcoming shows as well. So here's another, okay, here's a comment that we received. Thanks a lot, team. This is really insightful to be prepared proactively. Thank you so much, Jigger. I hope I'm pronouncing your name correct. If not, then please write your name properly so that I can greet you well with your name. But also, Poonam, I would like to ask another question regarding the topic, that are there any potential challenges or drawbacks, that employers and workers might face under this new H-1B rule, despite its pro-immigration and tech-friendly aspects?
Um, the challenges, the biggest challenge may be the compliance piece, and for as you've seen, the questions that have been coming from staffing agencies and companies that face employees that and clients, the biggest concern is the additional documentation. That I think will be the biggest burden under these new rules. Other than that, it's just codification. The benefit will be far more than the drawback. I think the only drawback will be additional documentation.
All right. Okay, so I think we can see very less challenges here and more pro-immigration and tech-friendly aspects in this new rule, and that's absolutely perfect, and that's lovely to know about it. Also, I would like to now come back to the comments that we received from our last episode because that is also very important to cover. So, Control, I would like to let us know about the comments that we got to know from our last episode. That is, I am currently on J1 visa and my visa expires in 2025. My spouse, who is a J2, his company is offering him L1 from India to the company here in US. I am not on government funded program as I am directly working for public school. Will he be able to transfer from J2 to L1 with recent changes to the skill list?
I'm assuming this person is from India, Sam. Assuming this person is from India,
Right.
then yes, they will be able to transfer because India was removed from the skills list and there is no 2 year home residency requirement applicable for this individual. To be 100% sure, my recommendation would be that they request an advisory opinion from the Department of State to avoid any surprises because while the J1 skills list has been updated, the officer's knowledge and comprehension of those rules may take some time to catch up. So, to that end, I would urge everyone that is in a situation where they think they will not be subject to the 2 year home residency requirement to please request an advisory opinion from the Department of State to benefit and to get clarity, have something to show when you go for that counselor appointment or when you apply to USCIS to support your not being subject to the 2 year home residency.
Absolutely. And here we have another comment too. That is, hello, I'm an Indian citizen. I was in J1 visa during the year 2021 as an exchange student. My program was self funded and I was subjected to 212E clause. I'm currently in US in my F1 visa. I didn't complete my 2 year in India. I'm in the process of preparing for applying to get my waiver. Based on the new updates, do I still need to apply for the waiver?
Great. Thanks, Sam, for bringing that up. So, 212E clause, to clarify, is the clause, is the regulation or the that requires the 2 year home residency requirement. So when this person says, I was subjected to the 212E clause, it means that they were subject to the 2 year home residency requirement. And that's what they say, that they haven't completed it and were applying for a waiver. As an Indian, they are no longer required to apply for a waiver. They say their program was self-funded, so I think it is fairly clear that they do not need to apply for a waiver. They are not subject to that. Again, if they have any doubt and to avoid any confusion on any agency's part, it may be worth requesting an advisory opinion to have a government document that confirms your understanding. So that is the best way to confirm and to avoid any doubt for anyone at any point.
All right. So yeah, I think these two comments were from that we received from our last episode, and I think Poonam, we have covered all the comments, all the viewers' question that we have received regarding our today's episode. So I think, yeah, that's lovely. And we also have come across 1 hour and we didn't even realize. And it's been more than an hour because it's obviously a very new topic. And thanks to you, Poonam, for, letting us know, for suggesting this topic. It's really amazing and it was so insightful. I enjoyed a lot this session and I hope you too. But meanwhile, also, Poonam, any last tip or any last message that you would like to share with our so many viewers today?
Sure. One of the things that everyone is concerned about, that we didn't get to talk about, is whether this new rule can be um, turned upside down or retracted when the Trump administration comes into office. The new rule goes into effect January 17th. The new administration comes into play on January 20th. What can they do to retract this new rule? So there are a few ways that things can change. One is obviously they can go to court and prevent something from going into effect or any of that. If that happens, obviously we will keep you posted. But barring that, all the other pieces, all the other actions that they could take are not immediate. If they want to modify the rule or change the rule drastically, they have to go through the notice and comment period that this rule went through. So, as I mentioned, this proposed rule was first issued in October of 2023. Comments were open until December of 2023, or November, 60 days. And then after that, the government issued a limited portion of that rule to implement the changes to the H-1B lottery. And again, it's taken them almost a year to address all the other comments that were raised with regards to this new rule, and they've issued this rule to go into effect. So any changes to this rule will have to go through the whole notice and comment period again, which will require some time. And even the best case scenario, it is at least a few months, potentially longer, before any changes can be implemented on a regulatory side. The Congress can always enact a new law, which, knowing what we know, I mean, with the government, I don't know, I haven't looked at the news this morning, but as of late last night, the government was going to shut down because the Congress couldn't come to an agreement on the budget. So, how well and how quickly that will pass is anyone's guess. So, to the extent that gives anyone any comfort, this rule is here to stay, at least in the near term. There are plenty of enforcement provisions within this that align with the incoming administration. So I'm hoping that, given the enforcement bent of this new rule will be left alone, and the new incoming administration also has different priorities, and this may not be as high on their priority list to tackle as other things, and mass deportation seem to be the top matter, and this is far from it. So I think we may be okay, but only time will tell.
Absolutely. And with Trump's administration, it's so unpredictable. We can't even predict what's going to happen. But
But we'll deal
let's,
with it.
yeah, absolutely. Let's see and what happens. And I would say, with that, Poonam, we have successfully done with our today's episode. And friends, we talk about the new H-1B rule, where we covered everything about like how is it a game changer, what are the key changes, and how is it impacting both the workers and the employers, and also what you need to do to stay ahead. So I think these were some of the very important topics that we talked about. And also, I would like to say, Poonam, that your expertise and your clarity on this topic, made everything so much easier to understand. And I'm sure, that our audience learned a lot from you. They loved your insights, and it's been a really pleasure having you on the show. And we are super excited to have more shows with you.
Likewise. Thank you, Sam, for having me. And it's great to be able to address the questions and, calm some of the people, the immigrants, get riled and get upset and anxious very quickly for good reason. And I'm happy to do my part to help whatever I can to help the immigrants in their journey. So good luck to everyone and happy to be here.
Wow. That's lovely and that's amazing. And thanks to our viewers also for joining us and participating in today's episode. I hope you found this session helpful. In case if you have any doubt, then go ahead and post them in the comment section. And also, if anyone is navigating the intricacies of visa applications or facing legal challenges or simply need guidance on immigration policies, then please feel free to contact Attorney Poonam Gupta on the given contact details. You can email her on info at summit-legal.com. And you can also visit her website, that is www.summit-legal.com. So this is the contact detail that has been displayed on the screen. You can go ahead and mail her, or you can also visit her website. All right. So thank you so much to everyone, to our attorney, to our viewers for joining us and making this session a great one. As always, stay informed, friends, by liking, sharing, and subscribing to the Immigration and Jobs Talk Show for more updates. I'm Sam signing off for now. Bye bye and take care.